A fraudulent transfer, also known as a fraudulent conveyance, refers to a transfer of property or assets made by a debtor with the intent to hinder, delay, or defraud creditors. In simple terms, it occurs when a person or company moves assets to another person or entity to avoid paying debts or to prevent creditors from reaching those assets. Fraudulent transfers are prohibited under various laws to ensure fairness in commercial dealings and to protect the rights of creditors. Legal framework. In India, the concept of fraudulent transfer is primarily governed by Section 53 of the Transfer of Property Act 1882, TPA. This section declares that any transfer of immovable property made with intent to defeat or delay creditors shall be voidable at the option of such creditors. Similarly, under Section 66 of the Insolvency and Bankruptcy Code, IBC 2016, transactions intended to defraud creditors can be set aside by the adjudicating authority. Under English law, the roots of this principle trace back to the Statute of Elizabeth, 13 Ely C5 1571, which made void any conveyance of land or goods made with the intent to delay, hinder, or defraud creditors. In the United States, similar provisions exist under the Uniform Fraudulent Transfer Act, UFTA, and now under the Uniform Voidable Transactions Act, UVTA. Essentials of a fraudulent transfer. For a transfer to be considered fraudulent, the following conditions are generally required. 1. Existence of a creditor. There must be a person or entity to whom the transferor owes a debt. 2. Transfer of property or asset. The debtor must have transferred ownership or control of property. 3. Intention to defraud, delay, or defeat creditors. The key element is the intention behind the transfer. 4. Inadequate consideration. The transfer is often made without fair value, suggesting a dishonest motive. It is important to note that a transfer is not automatically void, but voidable at the option of the creditor. This means that creditors can approach the court to have such transfers set aside. Types of fraudulent transfers. 1. Actual fraudulent transfer, where there is a clear, provable intent to defraud creditors. 2. Constructive fraudulent transfer, where the transferor receives less than reasonable value in exchange and the transfer leaves them insolvent, even if there was no explicit fraudulent intent. Landmark case laws. 1. Ramaswamy Chettiar vs. Malappa Reddyar, AR 1920 PC 86. The Privy Council held that for a transfer to be deemed fraudulent under Section 53 of the TPA, the intention to defeat or delay creditors must be proved. If the transfer is made for valuable consideration and in good faith, it cannot be considered fraudulent. 2. Alderson vs. Temple, 1768, 96 ER 384. This English case established that a transfer made with the purpose of keeping property out of creditors' reach is void, regardless of whether it benefits another person. 3. Official Liquidator, PA, Tendolkar, 1973 AR 1104. The Supreme Court of India held that fraudulent conduct includes deliberate acts to conceal assets or mislead creditors, and directors may be personally liable for such actions under corporate law. Conclusion. Fraudulent transfers undermine the integrity of financial transactions and creditor rights. The law, therefore, empowers courts to declare such transfers voidable and restore the property to the debtor's estate for equitable distribution among creditors. The essence of this doctrine is to prevent debtors from abusing their ownership rights to escape lawful obligations. It promotes fairness, transparency, and accountability in both personal and corporate insolvency contexts.